Welcome to the Atomic Level, the show where we decode the matters of wealth, one insightful conversation at a time, with the rising stars in finance, business, and tech, so that you can grow and protect your net worth as well as your net happiness. Today, we're doing a special Monday AMA. We're going to do a Shields and Succession AMA, this time with my guy, Owen Hathaway, because over the weekend, as we were talking through some things, he's come up with a new offering that he's going to be doing a lot of writing about based on what he calls the after loss consultation. And I thought it would be great to kind of unpack it with him in real time here for those of you on Substack. So, Owen, welcome to the Atomic Level.
Great to be here, Chris.
Clear my throat there, man. Oof. All right. So, thanks. As you guys fill up the room, feel free to share the link. We're going to do about an hour of back and forth Q&A. We got some audience questions from our Shields and Succession stuff. We've got some stuff that's been submitted to the firm. Now, just for the disclaimer, Owen Hathaway is a licensed attorney in the state of Colorado. He is not yet your attorney, and you may not live in the state of Colorado. So everything that you hear today is relevant for your conversations and useful as you do your own planning, forward planning, thinking about loved ones, thinking about your own estate. But none of it should be deemed legal advice as of yet. We do have ways for you to contact him. We are going to be putting together a 50-state guide that you could take with other attorneys that may be in your state. But for right now, we're going to use Colorado and Owen's career and learnings over the last several decades as the fodder for what we call this after loss consultation, because a lot of the things that happen that that seem like we should be prepared for, Owen, are ones that we're still surprised by as it relates to, like, where do we start when someone that we love or that we're the administrator for is no longer here. So let's just start with the high level of that. What is the inspiration behind kind of this after loss consultation offering that you're putting in, and why is it something so timely, do you think?
Yeah. So, Chris, the inspiration here is just the repeated calls that we've gotten over the years where nobody knows where to start. We don't know how to reach out to folks that need help, and folks um, call us, and the first question they usually ask after someone's died, do I need to open probate? I think I need to open probate. So, how much is that going to cost me, and how much time is it going to take? And when they call, the first answer I can only give is, I don't know. I don't know you. I don't maybe I know you from when we did your plan. I don't know, or your parents' plan, but I don't know what life looks like right now. So the only real way to answer the question is to sit down and get to know you, get to know what you're dealing with, and step through it. And so that was kind of the genesis of it. And we can talk a little bit more about what the process is, but that's where it comes from.
Yeah. So essentially, one of the goals here is to provide people a way where they could have something they could even maybe turn in, right? For lack of a better word, but
Mhm.
to spit and say, look, here's kind of a present state. I did this. I answered all these questions that otherwise you would do in a consult, and take that to their lawyer, in your case to you, and say,
Mhm.
okay, now what do I do first? And can you help me?
Yeah.
Uh, so let's talk through just today a lot of the questions, that some of which might be things you can answer well in advance. Other ones may not be something you can answer until you're really close to that kind of inevitable event. Or, God forbid, if people die in the wrong order, as Matt likes to say a lot, that you're kind of now reacting, and you're able to kind of fill those things in, because some of these things are going to be based on how it actually ends. And then others might be something you could prepare for in advance. Let's start with the ones that are a little bit more static, like they're probably not going to change that much, but you need to know. What are some of those questions that people should be documenting?
Yeah, so I always start these questions, and actually it's the same questions I start the planning process with, but now we're executing on the plan, which is, what do you have and who do you have? Yeah, everything stems from those two things. If you don't own anything when you die, and if we did a trust for you, you might not own anything when you die, we probably don't need to open probate. So that's kind of one of those starters that we've got to work through, is what actually do you have?
In your
And
name.
it's a
This is
big.
very specific, because what you
Mhm.
just said, I'm sure some people picked it up, but for those who didn't, if you've planned in a way where your trust owns all of your assets, that is not untrue anymore, meaning there aren't things that a pour over will would have to deal with, or
Mhm.
there aren't things that are in your personal name still that you own. It's possible. I don't know what percentage is likely, but it's possible that you don't even have to open probate,
Yeah.
because if nothing in your name, then there's nothing to open probate for.
Yeah, well, if you worked with us and we did an estate plan for you that includes a trust, and you signed all the paperwork we helped you get for signing to fund your trust, that'll be true, that you don't own anything. And so do you need to go to court? Nope. At that point, we're working from the plan that we put together, and we're executing on that plan. If something went haywire along the way in the planning, or I mean, one of the common ones we get here in Colorado, this actually will sometimes prompt a call to us. Hey, everything was going along fine. Mom died, and we were administering her trust, and we were getting through all of the steps we needed to, and then we got a letter from some gas outfit that was sending money to mom on a monthly basis, and they said they need a probate case opened or something like that so that we can get these gas rights. Sometimes there's things you own that you didn't even know about. You were just getting a check.
Mm,
So, yeah, so we got to know what you own, if anything. Um, the other big one though is who you have, and this is where, at least in our firm, we're doing a lot of triage. If there's propensity for conflict, if there are folks named in the documents or not named in the documents that are going to cause a fight, um, I'm upset that I didn't get what I thought was due, or I just don't like that my sibling is in charge because I want to be in charge. um, we need to know about those things early, because the as soon as there's any kind of hint of conflict, really important that we get all the documentation in line to make sure that we are doing things by the book. We're following the plan. If there's not a plan, if we're following the plan that the state of Colorado or your state has for you, we're documenting what we do every step along the way, so that if that conflict goes to court, we've got a paper trail.
I think, it's a good segue. We'll bounce around here, but since you brought that one up, it's a good segue to some of the things that come into play and that create tension or that create conflict, even if it's inner conflict, because you're trying to keep it from being with your sibling, right? Which
Mhm.
one of those things you talked about is the right to compensation for the administration side. A lot of times, maybe somebody's family doesn't know like who the actual executor is. Maybe it wasn't communicated until the event happens, and then the documents say, "Here's what it is." Maybe in other cases you did, but there wasn't real agreement. It was kind of like, okay,
Mhm.
well, that's what mom and dad want, or that's what whoever wants, right? But I don't know if I agree. Like maybe I should be the one, or I feel like I should be the one. And there's like that kind of unspoken thing. And then there's the person who's actually doing it, which is depending on the complexity, it could be a thankless job, right? You're not only in grief or now kind of, but you've added this burden. We wrote a lot
Yeah,
about,
congratulations, you just got hired as unpaid entertainment.
yeah. So, and then there's like well, you're getting money, we're getting money, but I have to do the work. Like, and a lot of times, people aren't aware of the fact that maybe there is a right to compensation. Um, uh,
Yeah, that's that's an important one. That's one that, it's one that comes up early. It's one I bring up in this, after loss consultation. Don't feel like if you pull the short straw and you have to do this work, that you have to do it for free. And don't feel like you have to spend your own money. If you're spending time and energy on this, even if you feel like it's your duty to do it, and that's what mom wanted, and I'm willing to do it for mom. Burnout's a real thing, and so when you're spending your weekends shoveling out the basement, because mom had a collection of quilting material and boxes and boxes there, um, you'd rather be doing something else with your weekend, I bet. So you might as well get some compensation. It doesn't make up for the time, but it does help you feel a little bit. Uh, it helps stave off resentment. Let's put it that way.
right.
So yeah, so definitely, unless the documents involved say that the trustee or executor is to serve uncompensated, the default is you're entitled to compensation. It's entitled to be fair and reasonable.
One of the things that people will likely find if they go into their favorite AI search engine, or if they go to even Google or one of the other ones, and they type in something, let's just say the phone rang and they got the call they didn't want or they weren't expecting. And they go, "What do I do?" Right? There's things out there like in the first 72 hours, do this, or in the da da da, do that. What's your thought?
Mhm.
What's your thought on that? And I know you have an
Yeah.
opinion. Yeah.
Yeah. Well, my first thought is if your first thought is to call an attorney, um, then I'm sorry for you. 'Cause that means you're in for a rough spot. I mean, they call us counselor, but, typically it's not that kind of a counselor. I mean, in the first 72 hours, you know, hug your family, call your loved ones, rally around the people that you care about. Let them rally around you. Be kind to each other. Let them be kind to you. Have some grace. There's very few things that an attorney can do to make that situation better. A lot of things we can do to make it worse, but not a lot we can do to make it better. So look for those things in your life that will help you, um, survive that first 72 hours. Um, so that being said, the paperwork, at least in Colorado, the paperwork that's required is basically all done for you. If someone dies in a hospital, the hospital's gonna take care of the paperwork. If someone dies outside the hospital, at least under Colorado law, that means a coroner is probably gonna have to get involved and determine cause of death and all these things. They'll file the report. Um, there's a few circumstances where you would need to file a report with the coroner, but it's really, really, really rare. I mean, the reality is there's almost always gonna be somebody around who, knows what to do and knows how to do it, in terms of getting the legal absolute minimum necessary things done. Um, so so let those professionals do their job.
Is there a time clock that's real that may be longer than people think? I mean, obviously, I think in human nature, a lot of times when something like this is there, we kind of don't want to dilly dally. I mean, we
Mhm.
procrastinate a little bit probably for certain reasons, but once we're kind of in it, it's like, okay, let me just get this, let's get through this and get to the other side.
Yeah.
There's also sometimes maybe some assumed timelines that could be working against us. May they put us under extra stress that maybe we don't need to worry about, or maybe we're worried about if we don't file a thing on a certain time, like probate's
Mhm.
gonna do this or that. Are there real things that we should be aware of that kind of take a priority? And then are there other things that are common misconceptions that people should know about?
Sure. So, I'm gonna speak from Colorado perspective 'cause, my understanding is not all states work the same way. At least in Colorado, the only thing that the statutes say has to happen immediately is anyone in possession of an original copy of a will needs to lodge that will with the court. Um, what are the penalties for not doing it? It doesn't really say. It just says "Thou shalt," and it doesn't say what happens if thou doesn't. Um, So, the idea there is you wanna get the wills out of the hands of lay people and into a place where it's controlled. You know, that being said, we had a case where, an original will got lodged in a criminal proceeding with a court, because the decedent was involved as the victim of a crime, and that Colorado court, after 90 days, destroyed the original will. Um and we kinda got stuck, with how do we open probate where we know there was a will, but that original will was destroyed by the court? That's pretty rare. Colorado has a thing called the Registrar of Wills, and their only job as a public official is to lodge those wills. So that's the one thing in Colorado that's statutory. Probate as a case may never need to be opened, so there's not a hard deadline. The deadline is, when you identify the fact that probate needs to be opened, you should do so in a reasonable amount of time.
Who
Um,
opens probate? Is that on the family to open it, or could it be opened against the family by the state?
yeah, so the only reason to open probate is to get a judge to bless the transfer of ownership of some property from one person to another. Um, and so if the person who died owned property in their own name, and we need to get that into someone else's name, and we don't have, a joint tenancy deed or beneficiary designations on all of our accounts, those kinds of things. Um, that's when we need to open a probate. And ultimately, it's the person who wants the property, who's it's their responsibility to open that probate case. 90% of the time, it's going to be the personal representative named in a will, or the person who has priority to be the personal representative. That's the term we use in Colorado for the executor. Um, and I think we did it to make it non-gender specific. And there's executor or executrix. Some states use administrator. These words all mean the same thing.
When
So that's who's real quick, Chris. That I said 90% of the time. The other 10% though is it's a creditor. If a creditor wants, to get paid and a probate case has not yet been opened, a creditor absolutely has the right to go open a case, and say, "Hey, judge, nobody's been appointed personal representative, so I'm gonna nominate myself personal representative." And guess what? Now that creditor has the right to control everything that person who died owned.
so one of the things I wanna say that's a great segue too. So one of the things I wanna segue to is like a real life, thing that could play out. So let's assume that there is a will and there's a trust. That's some combination of that. Um, and the person who is the administrator, you choose your synonym,
Yep.
is aware of that, and maybe they've reviewed that, and like they're familiar with it. So in the after
Mhm.
loss kind of consult or in the pre loss preparation, they're kind of feeling pretty solid, like on the wishes, right? Here's where they wanna die, or they wanna be cremated, or they want, like, because there's all that happening too,
Mhm.
right? It's like,
Yep.
that whole thing. And what kind of budgets there may or may not be, if there's a plot, if there's not, if there's a casket, if there's not, all those things. So they're dealing with all those things, but let's just say they have all that. A lot of times what they may not have is an accurate balance sheet, meaning they don't know what's on the other side of that ledger. They might know the asset column, but they may or may not be aware of the credit card or the
Yep.
tax lien or something else.
Yep.
And so in that scenario, usually that's going to be something they become aware of after loss, whether it's within the
Mhm.
first 72 hours or within the first 72 days. They're going to start opening up mail, or they're going to be in an inbox, or they're going to be getting messages. What do they do to kind of take the high ground, I guess, from a creditor? Because once that will is now public record and that person's dead, um, there's algorithms out there making sure that that's being
Mhm.
mined for things. When you think about things like unsecured debt, but you have an asset and a creditor knows how to play the game, how can you prevent yourself from wasting money on things you don't want to keep as it relates to
Yeah.
sowing the debts of the decedent?
Yeah, so I'd say the first thing is education. Know what you are required to pay and what you're not required to pay. Um, again, this is a very state specific thing. So every state's going to have a different statute that deals with what's required to get paid, what's not required to get paid. Excuse me. And so just brief weird thing about me, I've also done a bunch of bankruptcy work. And
Why I asked you the question, because you're the BK guy.
yeah, right. And it's funny, we use a lot of the same terms. In bankruptcy, you file a Chapter 7 bankruptcy, it creates a bankruptcy estate, which is everything you own and everything you owe gets put into this thing that's managed by, well, guess what? Someone called a trustee. Kind of the same thing when you die, except instead of calling it a bankruptcy estate, we call it the probate estate. And everything you own and everything you owe goes into this probate estate to be managed by a trustee, personal representative, pick your term. Um, and just like the bankruptcy code designates a set of priorities on who gets paid first and who gets paid last, probate code does the same thing. And so, who gets paid first? Well, if you're holding money that belongs to somebody else, they get their stuff back. If you were a trustee for someone else and you died, you can't be a trustee anymore. So anything that you held as trustee goes away. Next up is those administrative expenses. So paying yourself, paying the trustee, paying a personal representative, paying an attorney, paying a CPA to keep track of your books. um, if you live in a jurisdiction that has different priorities than Colorado, maybe paying for things like asset and debt discovery. So pull a credit report, those kinds of expenses. These are administrative expenses. They come off the top before you pay anybody else. definitely before you pay credit cards. And then federal taxes, state taxes, they get paid after the administrator. It's not till we get to the bottom of the list that we get to everyone else, which includes both secured and unsecured creditors. And that's where, I like to tell people, and this is true both in the bankruptcy code and under the probate code, pay for the things you want to keep. If there's a mortgage on the house and you want to keep the house because there's equity in the house, pay the mortgage and pay it out of the estate's accounts. If the estate doesn't have any liquid accounts, and you want to preserve that asset, you can't get the mortgage company to hold off on foreclosure. You know, that's probably one of the very few times I would say spend your own money. But absolutely keep records. Book that as a loan. You're making a loan to the estate. It's not something that you're on the hook for. It's just something you're doing to preserve that asset. Those credit card companies, they're at the very bottom of the list. They don't get paid till everybody else gets paid. So, uh,
What about like what about some risk scenarios where let's say that there's agreement or there's a plan and you pay off the mortgage or assume the house is free and clear. And now you've decided either if there's more than one potential beneficiary, those people have decided kind of on what the plan is because you can't carve a
mhm,
house in two, right? So you're either going to
yep,
have a tenancy in common or you're going to have somebody's going to buy the other one out. Assume that's the case and somebody's getting cash and the other one's getting the hard asset. But then like a long-term care bill that wasn't covered by insurance or something happens then, and now there's a lien against that estate. How do you kind of plan against those unforeseen things, like where maybe a medical bill or something? I'm trying to think of something that could be big enough, like something that kind of
yeah.
up where, again, I don't know where that lives as far as secured or unsecured, but
So in order to get a lien, they've got to have a basis for the lien. So that usually means either you signed something giving them the lien, like a mortgage, or a deed of trust, or
okay,
in the case of a car, they've got the title, right?
right.
So that's what we're talking about as a secured loan. Is if you can't
So if there
sell
was
the
never
property without.
yeah, if you never collateralize that asset against some other thing, then it's not
Yep,
something someone could kind of try and
yep,
get after the
yep.
fact.
Yep, you did mention, some medical debt. That's one of the ones that, is interesting. Colorado does give them a priority if it's the last illness of the person who died. What does that mean? Oh, it's the last illness? Hard to say. Um, as a statutory priority, letter of the law, medical debt dealing with the death has a priority over other debt. The reality that I've seen is when you send a death certificate to those medical providers, that's the last you ever hear of them. Now, that being said, how would you hear from them? Just sending a bill in the name of the person who died, that's not enough for you to have officially heard about it. So Colorado does have a procedure where you're supposed to file a notice in the newspaper of the locality where the person died, and do it for 4 weeks. And 4 months later, um, if no one has sent a claim to either the court or to the address listed on that notice, that debt doesn't exist. So if a medical provider has not sent that bill to the estate of Jane Doe at the address listed, Colorado has a very strict hard deadline. 4 months after that publication in the newspaper, if they haven't sent that, they're out of luck.
So with with creditors, one of the things just to kind of help people understand their rights, and again, every state's different, right? So use Colorado if that's what you have to use, but you can
Mhm,
extrapolate the rest with case law for the written version. Um, a will becomes public record, a trust is not. So depending on that, a creditor may or may not be aware of what the beneficiaries have coming to them. If there's a will, then a creditor can find out exactly what you or I have coming to us in that will. And if there's debt on that decedent, then um, certain creditor companies might play in the icky lay and they might come after you and I with threats and with demand letters and things like that saying, that's now ours, right? Whether it's a
mhm.
surviving spouse or whether it's a surviving beneficiary. Is there a difference, A, between a surviving spouse and that debt? And if so, what is it? What are they on the hook for? Specifically around like unsecured debt or things that are not necessarily collateralized, right? But that people will come after aggressively and
Okay.
try fear monger you into paying. The mistake would be to pay with your own money unsecured debt. I think that's
Yeah.
again, that's not legal advice. That's Chris's like, I ain't doing that. You gotta come get it from me. Try. It's unsecured for a reason. That's just my opinion. That's not everybody's comfort level. So from a lawyer,
Mhm.
what is the rights that we have that we could choose
Okay.
to execute?
So I like to say as a starting point on this part of the conversation, debt dies with the debtor. There's wrinkles to that. It's not an absolute rule, but that's just kind of my rule of thumb. That's the starting point. If this person died, you got to prove to me why someone ought to pay that other than the dead person who's dead
I
doesn't
don't
have
think
anything.
most people think that. I think a lot of people worry, and maybe they have a reason. So I want to hear the clarification of
Yeah,
where it doesn't apply because spouses, I think, in certain states, like worry a lot about this.
yeah. And spouses are probably the one case where it makes sense to worry a little bit more.
Yes.
And that's probably an area where you need to talk to a local attorney. Colorado has a law called the Family Purpose Doctrine. It is a statute that the legislature passed that says if debt was incurred for family purposes, so food, housing, utilities, clothing, things that are taking care of the family, that every adult in that household is responsible for that debt. Doesn't matter whose name is on it. Okay. so um, so, that that's typically gonna be things like rent, and this is my favorite. The statute does not say medical debt. Medical debt is not listed in the statute.
Really?
However, just about every court where there's significant population in Colorado has ruled not at the appellate level. So here I'm getting into the nerd lawyer thing a little bit. Not at the appellate level, but at the trial court level, they have consistently ruled that medical debt counts as family purpose. So a surviving spouse might end up on the hook for medical debt
Mm,
after becoming widowed or becoming a widower.
mm,
Um, my position has been still make them still make them make a play. I played some really bad high school football. We were a really bad football team. We got beat a lot, and that losing games meant that you got beat on a lot of plays. So in order to keep people from giving up and quitting the team, our coach had this thing he used to tell people. He said, "Look, if you get beat on a play, I'm not gonna yell at you, I'm not gonna take your butt off, but, if you get beat, make sure you make them make another play." And so that's kind of the mindset I take to this stuff. Let's at least make them make another play to collect their debt. They might be entitled to it, but let's make them, follow the letter of the law, and, and if they don't make the filings that they're required to file, they don't get paid.
right. Um, there's another angle to that too, which is part of the preventative side. So this is about things to kind of uncover in an after loss consult, like just to make sure somebody feels grounded in what they do and don't have to worry about what they do and don't have to deal with what they have in the way of executable plans and what's gray area or maybe not clear and that needs to be decided on. That's the after loss thing. Because once the
Mhm.
person's gone, you're kind of dealt with what you have and what you don't have, and you got to go from there. In front of that, though, you could think through some of these scenarios,
Yeah.
especially if someone is ill for quite a long time. Obviously, unfortunately, some people really battle with stuff for a long time, and then they end up, moving on to the other side. In which case, the surviving spouse might know, "Hey, I really need to plan against this if there's a debt here that somehow falls back to me."
Yeah.
So timing and everything matters when you move things into a trust, when you move them out of your name. Obviously, you can't do that last minute without some potential clawback.
Mhm.
But does that come into play here? Like if the debt is in the person's name and if the surviving spouse then absorbs some of that debt for any number of these statute reasons,
Mhm.
is there a strategy there that says, okay, yeah, but I don't own anything?
Yeah, actually, that's a wonderful follow-up question to what I was just talking about, because that falls right under that heading of making them make another play. If you cut to the end and what does the law say? The law says that those creditors are supposed to get paid. They're entitled to get paid, but the way they get paid changes when assets are in a trust. The trust code, the Uniform Trust Code, which is Colorado's adopted most of it, changed a little bit of it, and a lot of states have adopted this. Basically, says that if property, if a person owed money and they owned property that they transferred into a trust when they owed that debt, that property that they transferred into the trust can be levied by the creditors. And if that property that's been transferred into the trust has subsequently been distributed to beneficiaries of the trust, so take that out of the abstract. I own I own a house. I owed some credit card debt. Transfer the house into a trust. Then I die. My trustee, my son, decides to sell the house and distribute the proceeds amongst my 9 children. Um, I'm the oldest of 8.
Well,
Um, yeah, family reunions don't happen very often. Um, so the creditor, that credit card creditor does have a right to assert a claim against the trust and make the trustee claw back that distribution to those 9 kids. Um, but they've gotta follow that whole trail of breadcrumbs to get to the money, and that's where most unsecured creditors just don't have the appetite. They get that certificate of death, and you never hear from them again.
yeah, I would imagine too the amount matters, right? So, for instance, if we're talking about a $5,000 Capital One card,
Mhm.
probably not gonna have to hear from anybody because the amount they're gonna spend to go after getting some settlement on that 5 grand is a negative.
Mhm.
If if there's $150,000 worth of a line of credit somewhere, they might be going a couple
Yeah.
places.
Yeah, you're right. The amount does matter. We've seen in the $30,000 range, so, low, mid, 5 figures, where they just walk away, and most of the accounts or most of the estates we've seen, they don't have 1 account with 150. They've got maybe 4 or 5 with 30, and so each one of those is making that risk calculation on their own. It's not happening all at once. The other thing I would say is, if you've got $150,000 in credit card debt or a line of credit somewhere, you probably got the assets to cover it too somewhere. They're making risk-based decisions when they're issuing those things, and so making a payment to settle that debt on that estate probably isn't going to hurt as much as some of the folks that have the $5,000, where that may suck up most of the estate.
The other side of it would be, and I know my opinion here, but my opinion doesn't matter. I'm more interested in yours.
Sure.
The other side of it is one could take the approach. I would take the approach, whether other people agreed with me or not. That if that was the case and I was administering it, I'm not paying retail for any of it. So let's just assume that for all the reasons, I'm going to pay all of the creditors.
Mhm.
I'm the executor. That was the wishes. I'm going to honor the wishes. I'm going to pay all the creditors. But I have a fiduciary job now too to administer this estate to its beneficiaries.
Mhm.
I'm going to take that very seriously and I'm going to beat the snot out of every one of those creditors for the lowest settlement possible.
Yeah, that's always an option.
I'm not
Um,
saying that's a good option. I'm saying that's what I would incline to do. What is your thought of that? Like, is that even something that's worth is that almost a waste of time? Because or
it's
I don't know how I
not
feel.
the first card I'd play. First card I'd play is applying exemptions. For instance, a house in Colorado, if you're over 60, you get $350,000 in exemption on the equity in your house. I'd start playing those things. If there are minors involved, there's a family allowance. So, I'd start just denying claims. Just say, if I even get them. I mean, the the vast majority of the time, we never even properly receive the claim from the creditor.
That's it.
Uh,
That's another good one. So that's a really simple one, but one that's overlooked, and you're making me think of it. Mail. Okay, so after lost
yeah.
comes I mean, how do I get all the mail? Because mail used to be where everything came. Now it's like
Mhm.
mostly inboxes and 2FA and things like that. how does someone, I mean, I would assume if there's a legal thing, there still has to be certified mail, there has to be a
Mhm,
process that
mhm.
make that a legitimate, demand letter or claim.
Yep.
And so if that's the case, what are some of the mistakes or simplest ways to harness the mail situation
Yeah.
that you're
Yeah,
willing.
so this one is, this one we kinda played both sides of the fence a little bit on this one. Just real quick about debt. The answer is when we file that notification with in the newspaper, and we publish it and we say, "This is the person who died. If you think they owe you money, here's where to send it." If they don't send it like it says in the newspaper notice, you didn't get it. Colorado courts have been pretty hardcore about that. Um, so if there's mail at the person's house from Capital One that's to the person, that's to Jane Doe, that doesn't count. It has to be sent to the personal representative at the address, on the notice. Now, that being said, we've talked a few times about knowing the balance sheet, and, we've talked a lot here about the liability side of that balance sheet, but, we need to know the asset side too. A lot of times when folks pass, they've not been doing a great job of keeping track of everything they own. Maybe they've been shuffling accounts. Maybe someone had to shuffle accounts for them. So I actually tell people do open the mail. I've seen advice on the internet that says don't open the mail because then you know about the debt. I'd rather open the mail because I can find out about. I might be able to find out about assets that they had that we wouldn't have known about otherwise. So do get the mail. The post office will accept a forwarding for 6 months. So do forward it to whoever the person dealing with this stuff is. Forward it to them. If you don't want to put your personal address on there, get a PO box, pay for it out of the trust or the estate, and send it to the PO box. Um, that's
I think that's I mean, again, just being prudent with your own defense, like, anytime you can create a arm's length shield, I call it, right?
Yep.
Do right, a PO box is cheap. You can get them for a couple bucks a month. Whether you get a virtual one that scans and mails it to your other one, or whether you go to the UPS store or the local post office.
And a lot of those places will let you do it so it looks like a regular address too.
Yeah, yeah. I mean, there's a ton of them online. I think there's very little reasons anymore to use your personal address if you don't need to for anything, especially if you're going to be dealing with um, the estate of someone else or a potential creditor inbounds. Like you want to have access to everything, but you don't want to have your personal stuff out there.
Mhm.
So, all right. So we open the mail, we get the mail, we get a sense of both the asset and liability column. We have the trust and or the will structure and documents. Digital. How do we deal with winding up the digital stuff?
Which digital stuff? Man,
Exactly.
that's we
All
could
of it.
spend an hour just on this.
Well, and
I've
let's contextualize it around not only the risk, because there's risk, but then there's also just the grieving process is also difficult when things are out there that maybe we can't shut down, but we'd like to, whatever it may
Mhm.
be, the profile or whatever that we keep coming across. Or
Yeah.
and then there's other things where maybe part of the legacy is we want to kind of create a memoriam or some kind of thing where that perpetuates because maybe they were a patriarch or a matriarch of the family business and
Mhm.
maybe there's a strategy there too that was even part of the wishes or design. But at the end of the day, just understanding the digital footprint is harder and harder, even with boomers who were not natively or
Mhm.
even the first people in the digital. Gen X,
Yeah,
it's harder. Gen X is not getting any younger. So we
yeah.
are going to be next. So what is the approach to that in after
Yeah,
loss?
it really comes, back to figuring out the what is that footprint. Everybody's got a different method for dealing with it. Facebook has changed their minds 3 times at least on how they wanna deal with it. Um, Most of the socials have a policy, once they receive notice that someone has passed. Some of them require, the notice come from the official representative of the estate, and some of them just turn off the account. Some of them will turn it into an in memoriam account, and leave the account up there. Sometimes that changes things, like the inability to post, or those kinds of things. It just kind of depends on the service. Um, LinkedIn, um, they've been fun. I still get notices about the work anniversary of a colleague of mine who passed away 10 years ago. Um, I don't think we're celebrating that anniversary. Um, so it's going to be, do a Google search, find find everywhere they're mentioned, and follow the individual policies for that particular social. Apple has a pretty nice feature. They've got a digital vault feature for the iCloud account that's tied to all your Apple devices. Um, so this is something people can do while they're still alive. If you're an Apple person in any way, shape, or form, make sure you do that digital representative, that digital vault. It's an offline archive of recovery keys. So they'll give you a list, just like if you're doing the two-factor authentication registration and you get the recovery keys for that, you'll get the recovery keys for your Apple account. Put that in with your trust. Um, let's see, digital assets. It's still Wild West out there for digital assets. You want to talk about how to get crypto? Um, Physical custody is really the only way you can absolutely guarantee you're going to get it. So if you've got your crypto in a physical wallet, you're in good shape as long as you know what the keys, what the passphrases are. Um, but if you're in Coinbase, um, you know, if you're in Binance, you got to go through them. They are not they do not take the position that those assets are assets. They take the position that they are providing a service, and therefore everything is subject to the terms of the contract on their terms of service. If you were to do something like Colorado has this thing called a small estate affidavit that says, yeah, this person died, but they had less than $88,000 worth of stuff. um, so you sign that, get it notarized. You're supposed to be able to take that to anybody who has property that belonged to the person who died, and they have a legal obligation to give it to you. In fact, you can sue them, and they owe the attorney fees if they don't give it to you. Not so much with not so much with the crypto exchanges. They've said, "Yeah, we don't have any property. We just have a service that we agreed to provide for that person." You know, never mind how many zeros are after the decimal point on that. They're saying, "Nope, just a service." So, you know,
Yeah, I think there's a so breaking this down, there's like the digital footprint, which we think of now as social, email, the different bank, the bank accounts, the insurance, the logins, all that. Where is that? Is that in a Bitwarden? Is that in a LastPass? Is that in you pick your solution provider? If so, then
yeah, do one of those. Pick one. Do
yeah,
one.
pick one, and then just make sure that whoever the potential administrator, executor is going to be has that in advance so that
Mhm.
they are an admin or they are at least able to have direct access to that so that they have a chance and they're not going off of your laptop or something's memory, right? In
Yeah.
case something happens to that laptop or it's lost or what have you. The other side of it, you mentioned the iCloud Vault. That's something to look into for people that are in Apple. For people that are on Android or Google, and you're using Google Authenticator, for instance, which is a common one for the 2FA stuff. If it's not just coming to a text message, there's a way to clone that. So, like, you can have your phone and your spouse's phone, or your phone and your next of kin's phone.
Yep.
They can Google Authenticator on their phone, and then you can basically mirror all of your 2FA codes to their device so that if something happened and you died with your phone or your phone is locked and no one can get into it for some reason, that at least they have the 2FA countdown just like you did.
Yep.
And you've mirrored that. I've done that with my wife. You have to update it because a lot of times you'll add accounts
Yep.
and you'll have new 2FAs. And the last time you updated it was a year ago. And so she or he may have 80% of it, but not 100% of it. So it's something that you'd have like maybe biannually or at least on your birthday, like just something to check in, right? Put an arbitrary thing to make sure that everybody's got at least a backup
Change
copy.
the clocks, change the clocks, and then
That's a good one.
update your
Yeah.
2FA, and then go
Yeah.
change all the batteries in your smoke detectors.
Yeah, exactly. One of those things. The digital assets themselves, things if you have any kind of significant assets, and I would consider anything above, you know, 0 right now significant because, again, you don't know what the future is gonna hold for things like Bitcoin, things like that. If you have something worth holding on to, then, at some point, for as little as $10 a month, you can get a multi-sig solution from Casa or someone like that. You can if you have real assets in there, you can look at an Unchained. We've done some work with them. They're great over there, more of a custodial solution for multi-sig, and these will give you a way where your seed phrases, can have you and another person and then like a third party that's kind of trusted holding an extra copy just in the event that one person dies and you can't move it with just one signature, but you have multi signatures. And that way you have something in place where you could get into it. Now, like you said, if it's hot wallet, if it's on an exchange, you got to realize just like at the bank, it's not your crypto if it's in their exchange, right? Not your keys, not your crypto, not in your vault, not your money. So if it's at Chase, it ain't your money. It's a claim against the money you gave Chase for custody in exchange for that terrible interest rate. So, these are things that you do want to understand if the person who is deceased or will be at some point
Yeah.
has. And
And I think, Chris, we've said it a few times, and as you're talking that through, it just solidifies in my mind. It's so important to know what you have, the asset side of that balance sheet. Have that in an inventory, have that in a notebook. Um, you know, there's just no way to find all this stuff. There's no international registry of people's assets. I
right,
can run a credit check and maybe find out. I can do a pretty good job of finding out what you owe. There's no universal registry of what you own. So,
right.
leave a trail of breadcrumbs behind you. Put a copy of a physical paper copy of a statement for all of these things in the binder with your will or trust. Even if it's just a note that says, "I've got this thing over here," at least I know where to go find it. Because if I'm a trustee and I don't know about it, can't get it.
Yeah, and then there's the other side of preparing someone for things they didn't want to find, whether it be social media accounts that were hidden, Tinder accounts that were hidden, things that are tough, right?
Yeah,
And yet shutting those things down is important. There are some pretty disgusting moves, and I don't have any problem calling them out. You're not doing this. This is not Owen's opinion. This is Chris Snook's opinion solely. But Facebook's doing some
thanks.
really evil stuff, and I say that because one of the reasons why, if you're even on that platform, you really have to prepare for it is because they filed a patent. I don't think it's been issued yet, but they filed a patent within the last 6 months around the ability to essentially have the rights to continue posting as your ghost if you're on their platform. They see that as their property, not yours, right? And there's a whole diatribe anyone who wants to hear me say about that. But the end of the day, Instagram just came out and said that they're going to basically use your photo to allow for AI generated images. So you have to really decide if these places are places you still want to be and why and what the value exchange is. But assume that someone that you are taking care of the state is or has been. Winding that up properly is a pain in the butt, but something that you do have to really think about because Facebook's patent literally said that they thought it was a bad user experience to stop hearing from the dead person in their feed. And so instead of it being about the person's family and the person who died's best interest, they were worried about the followers and their thing. There's a very almost inhumane aspect of that, but that patent's been filed. And so um just understand winding these things up is prudent and that you kind of need to know how you can get in there and do that.
I don't think we've brought it up. A little more mundane, a little more 20th century. Um, make sure Social Security knows this person died. Um,
Yeah. Yeah, talk
you
about that
know,
because I actually think that's assumed. I think a lot of people think, "Oh, I got a death certificate," and maybe that is handled. I don't know. I don't know how that
yeah.
gets how does that get handled?
So, a lot of the public agencies will notify Social Security that the person died. So it usually happens. They usually find out that the person died. It doesn't always happen right away. And I'd say about half the time someone comes in to talk about this, and they've got a bank account that belonged to the dead person who's been receiving Social Security. Maybe wait a couple months after Social Security has had a chance to take back money. Um, because once you pass away, you're no longer entitled to Social Security, at least not in your own name. Maybe there's survivor benefits, maybe there aren't. But
Unless you're one of those 330 people that, Doge found, right? That were, like,
right,
100 years old that were still getting checks.
right. But how do you get on that list?
I'm
I'm not sure.
not sure either. I don't
Yeah,
think
so Social Security is gonna probably take that money back, and guess what? That doesn't inactivate your Social Security number. Um, and
so
your
what
Social
actually deactivates your Social Security number? You have to file
filing a final tax return. There's a little checkbox at the very top of the 1040 that says at least one of the taxpayers on this return is deceased, and here's their date of death. So even if there's no taxes due, make sure you get that final tax return filed just so you get that notification to the IRS. This person's gone. That it's kind of hard to open a new credit account on a social security number that's been deactivated. um, dead people apparently buy a lot of houses.
Gotcha.
I didn't know that. It's usually not the dead person or their estate doing it, if you know what I mean.
Right, right, yeah, because there's probably a whole portal for the dark web to kind of find out who hasn't done that properly and then just kind of milk those numbers
Yeah,
until
an active social security number that's got nobody paying attention to object is gold.
right, right, yeah, interesting. Yeah, that's the method though, is one of the things is you finalize that final tax return. Does that mean you file it early, or do you have to wait until that annual filing? Like, is there a reason why someone would file it in the like, let's say that, someone passed
Mhm,
away in April of this year, right? So,
mhm.
they'd have a whole year basically before they'd have to technically file. If someone passed away in April, would the family look at filing that return early for 2026?
So the legal answer is no. Until you know what once you know what the person's income was for that tax year, you basically have everything you need to file a tax return. Now that being said, pragmatically speaking, none of the forms are gonna be available until February of the following year. So, you know, odds are you need a 1099 that hasn't been issued, a W-2 that hasn't been issued. You're not gonna
K-1,
have any of those things.
yeah,
K-1s, you
essentially,
know,
right.
if you're the one issuing the K-1s, maybe you can do that, but the 1065 the 1065 for 2026 isn't out yet, and it isn't gonna be out for a while. So,
There's something someone could do in the prevention of kind of this buffer period, for lack of a better word. Is there something someone could do to kind of, freeze the credit? I would imagine that's what they would do, right? They would freeze the
yeah.
credit with the FICO bureaus so that if it wasn't already frozen, that during that limbo period, the dark web couldn't do what you just said.
Yeah, an agent, a person acting as a personal representative does have the authority to do that. Absolutely.
And that's where the power of attorney on the financial side would kick in, and you'd be able to do that kind of thing potentially?
Yeah, power of attorney dies with you. So you gotta do that while you're preparing. But a power of attorney does have the authority to do that. And then if you wanna do it after the person's died, that would be a potential reason to open probate if it's something you're worried about, because you do have to have that authority as the personal representative.
Okay, and a durable power of attorney wouldn't cover that?
No, because the durable power of attorney dies with you. It's durable during your incapacity,
Oh,
but
okay. Gotcha.
but
Okay.
not
Yeah.
not it's only conferring authority that you have, and your authority expires with you. Um, that's the other side of the will that doesn't do anything until you die.
So another just practical step would be people are aging. Assume that this is not one of the unfortunate ones where we can get the call and it's a surprise, because unfortunately that's a lot of people that have to try and deal with this after loss. Assume this is one where we kind of know, we're coming in to the final couple laps, whatever that may be, unless mom or dad in this case, or unless the loved one who is older is likely to go out and buy another asset, they probably don't need their credit. And
Yeah.
so it's probably a good idea after a certain age, if you're not out there like leasing cars, doing that kind of stuff, to just freeze your credit, right?
Yeah, that's something we've helped a lot of people do. Um, it's more of an advice thing because we can't really do much about it. It's, do it as a power of attorney. Um, we could spend a whole hour on things to do just to prepare, as mom is going into a home. Lots of things. That's definitely one of them. The things we talked about with mail. If you are a power of attorney and have a valid power of attorney, absolutely, yeah, do that. Now, I mean, I'm an attorney, so that means I have two hands. On the other hand, those are also all signals of isolation. And so if you see those kinds of things happening and it's a loved one that you have any question about whether the person doing these has their best interests in mind,
Mhm.
you need to raise that as an issue. And like I said, that's a whole other hour to deal with.
Right, right, yeah. We'll have to maybe have you back on that one because isolation, we could do a thing about signs of isolation, you know,
Hmm.
um, and then also if it's totally above board, how to communicate properly with those who are not maybe in the execution mode, so
Hmm.
that if they have concerns, there's not like an unnecessary conflict, right? Because
Yeah.
again, all these things related to sewing up the estate could look like they're prudent, but they also could be done by someone who might be more predatory in
Yeah.
their reason.
Yeah, and I mean that goes back to what we talked about at the very beginning, knowing who's in your life, and who those people are, and if everybody is coming into the situation, with clean hands and in good faith, open communication is huge. I'm a big fan of the site Caring Bridge. I don't know if you've ever used that one.
I haven't used it,
Um,
but I've heard of it, yeah.
yeah, so it's a real limited social media site that's all about someone who's in a health crisis of some sort. And it's a way for the person dealing with the crisis to communicate with anybody who might be interested. And so I highly recommend it for anybody who's dealing with this stuff who wants to be able to provide updates, but doesn't want to have the same conversation 6 different times and answer the same questions. And take the time to do that, but also live through the personal trauma of having to recount it all those times. So, big fan of Caring Bridge. They're a nonprofit, so if you want to make a donation, that they do wonderful work.
Awesome. Well, Owen, we'll have to have you back, guys. For those who have tuned in live, thank you for this. If you're listening on replay, make sure you check out Owen. He's newer to Substack, but he's going to be writing more and more here. He's got some great stuff. You can also check him out at yourtrustedplanner.com. The phone numbers, if anybody is in Colorado, you can dial 970-820-0090 and talk with a human and have some questions answered personally at no cost, to see if there's anything that they can help you with down the road or in the immediate. All 50 states, if you're looking at some of the higher wealth stuff, you know this from Matt chats and stuff I do with Matt Miley. You can call 307-463-3600. So again, give Owen some love, subscribe, follow him on Substack. We'll have you back, buddy, for another AMA. I think we should do one
All right.
around relation thing. I think we should kind of expand on that a little bit and
Yeah.
help understand some of the signals that to look out for, some of the ones to kind of proactively mitigate against other people's fears around. If you're the one kind of doing things for the right reasons, that could be some good stuff. So let us know in the feedback in the comments if that's interesting. We'll be back here tomorrow. I've got Unicus Investor on a Rising Star in Finance talking about macro and the stuff they're writing about. So tune in for that one on Atomic Level Live. Wednesday, Matt and I will be here for another office hours on Shields and Succession at our normal time. Heinrich, I see you in the feed. Thanks, buddy. I can't wait to interview Heinrich Zieberg on Thursday. We're going to have him coming in from Europe on Thursday, and then Friday, Generative Advisor. So we got an action-packed week of atomic level AMAs and lives for you this week. Owen, awesome, man. I will let you have the
Thanks,
final
Chris.
word and see you next time.
Oh yeah, I wish I had some great dad advice to give here, but I'm all out. I guess I'll just leave you with hug your mom. You
Hug
may
your
never
mom.
get another chance.
Yeah, hug your dad too. He likes hugs. I like hugs.
Yeah.
My kids with me. I like a hug now and then, so that's good. All right,
All
everybody.
right.
Thanks for tuning in. We'll see you guys next time.